Good morning, everybody. I'm going to speak about the Pregnant Workers Fairness Act. Hopefully it does ring a bell because unlike the Equal Pay Act, it is law now. If it doesn't ring a bell, then you should really pay attention. If not, and if this does ring a bell, then this is an opportunity, I guess, to sort of double check your work and double check your policies and make sure that they're in compliance. As I just said, it's law. It became effective April 1st. It was passed by the Massachusetts legislature last summer. Dave Rogers later on might have some comments about that. Interestingly, it was added to the Massachusetts Fair Employment Practices Act, which is 151B. That has two important practical effects. First of all, it means it only applies to employers with more than 6 employees. If you do not employ 6 or more employees, then this act does not apply. The other thing is that it's enforced by the Massachusetts Commission Against Discrimination. And in fact, I'll discuss some of the guidance that the Mass Commission Against Discrimination has put out. Now, one area where it's not really a change of the law is that the idea of pregnancy being a protected class, that's not really new. But in terms of what protections expressly go out to pregnant or nursing employees is new. I would say that to boil down the act, you could say that there's three do's and 3 don'ts. The first do for an employer is to provide reasonable accommodations for an employee's pregnancy or condition related to pregnancy. A condition related to pregnancy means something that affects the pregnancy both during and after the pregnancy, not just during the 9 months of pregnancy, but also during the nursing process when there's a newborn infant. The only way to get around a reasonable accommodation is where an employer can prove that the accommodation would create an undue hardship. I'll discuss what an undue hardship is later on. The second do is to engage in a timely, good faith, interactive dialogue with an employee or a prospective employee when that employee or prospective employee makes a request for accommodation. Now, the Act and the guidance don't define what is timely, but obviously with pregnancy, there are very time-sensitive accommodations that need to be taken into consideration. So it's important to be very proactive as an employer when an employee or prospective employee comes to you to explain that she is pregnant. The third do is to provide non-bathroom space for employees to express breast milk. That's very important, and that's something that you should be thinking about even if you don't currently have any nursing mothers. It will require some sort of private space that's away from other employees, customers, and the general public. I think that's very important and worth a lot of consideration. In terms of the don'ts, employers cannot take any adverse action against an employee who requests or uses a reasonable accommodation due to pregnancy or related to a condition of pregnancy or refusing to hire a job applicant because of pregnancy. So if you're interviewing someone and they tell you, I'm 3 months pregnant, I'm expecting in 6 months, and that factors into your decision as to whether to not hire that employee, that's a violation of the Act. It also sort of encompasses an anti-retaliation provision. If an employee requests an accommodation, do not retaliate against that employee. Adverse action also includes reinstatement. So if, as part of the accommodation, the employee goes on leave for a certain amount of time, they must be reinstated with an equal or equivalent position and equal pay and benefits, including seniority, fringe benefits, retirement accounts. The second don't is do not dictate to your employee what accommodation you believe is appropriate for that employee. The accommodation has to be related to the essential functions. I think one example, just that off the top of my head, if you have a bartender or server who says that they're pregnant and they start to show, and you ask that bartender or server to go to the back of the house, not because of the pregnancy, but because you don't know if people want to be served by someone who's pregnant. That's a violation of the Act. The third don't is to require an employee to take leave if the employee wants to stay and work with reasonable accommodation. So obviously, there's the parental leave. There's also FMLA. If you're an employer that is of a size more than 50 employees that the FMLA applies to, or the parental leave, then the option of an unpaid leave of a certain time is an option for the employee, but the employer cannot dictate that to the employee. I don't think that an employee will necessarily be asking for unpaid leave, but if, for example, if you have a paid leave policy, I don't think the employee will mind if you tell the employee that they're welcome to take the paid leave. But if you're going to insist to the employee that they have to take the unpaid leave rather than to accommodate them, then that will create issues under the Act. Unlike the anti-disability discrimination laws, the Pregnant Workers Fairness Act actually spells out several examples of what a reasonable accommodation is. It spells out in the statute 9 different examples of reasonable accommodations for pregnant employees or those who became recent mothers. The first is more frequent or longer paid or unpaid breaks. Whether or not the break is paid or unpaid depends on what the employer's policies are. So in other words, this pregnant or nursing employee can't be treated any worse than other employees. So if the employer permits employees to take 10-minute paid cigarette breaks, then it must provide comparable breaks to a pregnant or nursing employee for other purposes. Another reasonable accommodation is, of course, time off or leave to attend to the pregnancy or to complications relating to pregnancy or to recover from childbirth with or without pay. And again, this is based on what the employer's policy is. So if the employer allows for paid personal time at their discretion and they allow employees to use that paid personal time, then they should also use it for those employees, for the pregnant employees. This also may matter if an employee is not eligible for FMLA leave or parental leave, either because the employer is between 6 and 50 employees, or if the employee has not worked sufficient hours to qualify for a leave. This is basically a way to tie in leave for any employee because of pregnancy, regardless of the size and regardless of the amount of hours that have been worked. 2 other accommodations are job restructuring or a modified work schedule, and then, as I mentioned earlier, the private non-bathroom space for expressing breast milk. 4 other accommodations that are listed under the statute are modified equipment or seating, a temporary transfer to less strenuous or hazardous positions, light duty, which I believe is geared more towards lifting requirements of a job, and then assistance with manual labor. One thing that an employer is not required to do is an employer is not required to discharge or transfer another employee to accommodate the pregnant or nursing employee. So as I said earlier, I would discuss what an undue hardship is, and it's a really hard thing for an employer to meet. The MCAD guidance says expressly that for a hardship to be undue, it must be of a significant expense or difficulty. So that will be very difficult to show. It will be the employer's burden to show the undue hardship. And the statute lists 4 different factors for consideration. It's the 4 are the nature and cost of the needed accommodation, the overall financial resources of the employer, the overall size of the employer's business, and the accommodation's effect on expenses and resources. Basically, the reading between the lines is if you are a big company, you should be able to reasonably accommodate your employees for pregnancy or conditions related to pregnancy. Smaller employers, you may have a better argument, but again, it's a very tough burden to meet, and I would not recommend it is one that you hang your hat on. If you feel like you do need to rely on undue hardship, then you need to think about that very much so when you're engaged in the interactive process with the employee and you're going through back and forth about what the accommodation should be. Now, for those of you who are very familiar with ADA law and accommodating disabled or handicapped employees, you might be saying, okay, I treat pregnancy no different than any disability. That would be a mistake because there's a key distinction between the Pregnant Workers Fairness Act and general anti-discrimination laws for disability and handicap. An employer cannot require medical documentation for 4 different accommodations. Those are more frequent restroom, food and water breaks, seating, limits on lifting more than 20 pounds, or the private non-bathroom space for expressing breast milk. So normally in an ADA accommodation case, you would say to your employee, you know, I'd like to see some medical documentation to corroborate. I'd like to talk to your physician, and we'll fill out the forms. If all they're asking for are one or several of these 4, do not ask for medical documentation. Do not ask to speak with the employee's physician. The other key distinction is that FMLA and parental leave each have set times for the amount of leave. The Pregnant Workers Fairness Act does not set forth that. It will be based on what the circumstances are, whether there's undue hardship to the employer or whether there's some sort of operational difficulty that makes it an unreasonable accommodation. The MCAD has published 2 different guidances. One is just called a guidance, and one is a question and answer format. They're very easy to find on Google or on the MCAD website. I think that might be the first, if you have a question or a concern about your compliance, that might be the first place to go to figure out if you are in compliance. Again, the MCAD defines an undue hardship as significant difficulty or expense, and it also explains that private space for expressing breast milk should be free from intrusion by other employees, visitors, and the public, and should be convenient and comfortable for the employee. Having said that, if an employee has a private office that is sufficiently private, that can also be an appropriate place. It does not need to be away from an employee's desk. It depends on the circumstances. What are some of the important takeaways for how to ensure compliance with the Massachusetts Pregnant Workers Fairness Act? So the first is to ensure that handbooks, written policies, employment notices are up to date. Again, this law already took effect, so to the extent that you don't already have that, you should be doing that promptly. And it should incorporate within it the policies and procedures to ensure compliance with this act. It's important under the act, notice must be given to all new employees and any employee or prospective employee who provides notice to the employer of pregnancy or a condition related to pregnancy. And according to the law, there needs to be notice given within 10 days of the date that an employee provides the notification. So in other words, once the employee provides that notification, whether it's informal or formal, then the clock starts ticking for the employer to provide the written notice. And this could lead to if you have not trained your managerial employees on this, this could lead to very easy technical violations of the act. For example, an employee comes and says, I'm 4 months pregnant, my due date is in 5 months from now, and the managerial employee sits on it for several weeks before notifying HR. The employer has not provided the notice. That's a technical violation of the act, and it's all spelled out there. Ignorance will not be looked at kindly by the MCAD, whoever else is enforcing it. The employer should also always be thinking about reasonable accommodations, what they can offer to their employees, their pregnant employees or their nursing employees, in particular, obviously the private non-bathroom space for expressing breast milk. Make sure that HR staff and managerial employees are trained to not ask for medical documentation depending on what the specific accommodations that the employee asked for. So again, if they're the opportunity to sit during the workday, limits on lifting less than 20 pounds, expressing breast milk in a private non-bathroom space, as well as more frequent restroom breaks, the employer cannot ask for medical documentation. Also, do not think of this as some sort of set time period for leave. It's based on the circumstances. It's based on how that affects the employer's operation and whether the employer can accommodate the employee. Finally, when you have issues, you should consult with either the MCAD guidance or the Q&A, or you should contact an attorney, whether it's in-house or someone at our firm would be happy to speak with you about that.